Name of Almighty Allah, the most merciful. The topic I'd like to introduce today relates to management of company after the due incorporation of a company. If it is a private company, then it is allowed under the law to commence its business. And if it is a public company, then of course, minimum number of subscription after the fulfillment of that on its initial public offering, the company is allowed to commence its business. Now, once business is commenced, the key point is that how the company be managed. What will be the management of the company? So let's have a look at this key question. Mr. Mutahir, please do the reading.
Definition: a company is an artificial person created by law. It has no physical existence, so it acts through some natural person. The shareholders give the actual management to their elected representatives called directors who act on behalf of the company. The directors of the company are collectively known as the board of directors. The board of directors is headed by a chief executive officer, CEO.
Okay, let's pause. So chief executive officer is the head of board of directors, and board of directors members are duly elected. In other words, the composition of board of directors is made on the basis of elections. And these elections of the companies are held in their annual general meetings. And initially, at the time of commencement of business, normally promoters, they become the first directors of the company. And subsequently, elections are held under the auspices of that board of directors, the first board of directors, the promoters board of directors, in other words. And once on the basis of elections, new directors are elected, and they do nominate, select among themselves one of the member as chief executive officer. And you have rightly pointed out, Mr. Mutahir, that the company actually is an artificial legal person. And we have studied in civil aviation's case, corporate law decisions 2011, we found that though the director has signed, but it is considered that the director has signed on behalf of the company. So basically, it is not the director, the physical man, the natural person, but the company actually signing, because company cannot act being artificial legal person. So someone has to act on behalf of the company. But if something goes wrong, or if there is any litigation, or if there is any claim, that claim will be against the company, not against the individual who is the signatory to any contract. Any violation of any infringement of the contract will not constitute or make that very director liable who is the signatory of that contract. Now, director includes any person occupying the position of a director by whatever name called. So, subsections 25 and 1 of section 2 of Company Act that explains that. And you see here, the position of a director, we will be discussing at length. So whosoever occupies that position, maybe temporarily, a stopgap arrangement is made and someone has assumed the office of a director, and that assumption of an office will be considered that the director is performing the duties. Now, position of directors, Ms. Amna Beg, please share with the participants.
Directors are agents as well as trustees of the company. Agent. A company is an artificial person created by law, and it acts through agents known as directors. The relationship between company and director is that of a principal and his agents. The directors are not personally liable for contracts made on behalf of the company if they act within their powers. If directors exceed their powers, the company can hold them liable.
Absolutely right. So now this is what is civil aviation's case is based on, and this is why Mr. Arshad Salim, who was one of the director of the company, he was held not involved, was absolved by the court of law. He was exonerated from any liability because he signed that agreement with Civil Aviation Authority on behalf of the company. So all these powers are used or executed on behalf of the company. So they are not liable in their personal capacity. But this is the key point, that the liability can accrue. The liability can be placed on a director if he exceeds from his powers. He has given certain limitations, and if he is not bearing in mind those limitations, and he has, you see, exceeded his power, then of course he can be made liable personally. But if he remains within the purview, if he remains within the mischief of his powers allotted to him, granted to him, then we cannot say that he's personally liable for any wrongdoing, or he's personally liable for any contractual obligations, debts. It is the company actually which will be liable. Trustees. You see, we use the word fiduciary. Fiduciary. Fiduciary means trust. The directors actually, they act like trustees of the company. We will study further this very point. Mr. Mehdi Raza, if you can hear me, please read this point. Hamza, Mr. Hamza, if you can. Mr. Hamza, can you do the reading, please? Mr. Osama bin Rashid, can you do the reading?
Sir.
Yes, Mr. Osama, please.
Trustees. The directors are the trustees of the company's money, property, and powers given to them. The directors are appointed to run the affairs of the company and for the benefit of shareholders. The relationship between the company and the directors is that of trust, and so they must perform their duties honestly in the interest of the company and all the shareholders.
Absolutely right. So basically, they have to perform the fiduciary duties as trustees. They have to act interest of the company. They should not safeguard their vested interests. This is the basic understanding. This is the basic principle of fairness and equity. And this is why any conflict of interest, especially in public companies, if any director is an interested director for a certain contract, he's not allowed to vote for that. But it is different in private companies, as you know. Next point, let's have Ms. Mehrun Nisa. Ms. Mehrun Nisa, please share number of directors point with the participants.
Of directors. The number of directors for different companies is as under Section 154. Single member company shall have at least one director. Two private company shall have at least two directors. Three public company other than a listed company shall have at least three directors. Four listed companies shall have at least seven directors. Public interest companies shall be required to try to have female representation on their board as may be specified by the commission. The relevant statutory
Right. Thank you very much for the management of company. Number of directors are given, as you know that if it is a listed company and it is a public company, then at least seven directors are required for a listed company. And as you know that listed companies are the key players for the market, for the economy of a country. The corporate sector is run through the listed companies, and listed companies are one which are their shares are traded, people make investment, and resultantly the very wheel of economy, it moves on. And this is why at least seven directors is a requirement. And furthermore, when we will study the types of directors, we will find that there are executive directors, there are non-executive directors. On the board, it is a mandatory requirement that there has to be a female director once we will study the corporate governance regulations meant for the listed companies. So for listed companies, the requirements, as I have already mentioned, are very stringent. Listed companies, as I said, are the backbone of economy. And listed companies are one where not only the citizens, country, they make investment, but there are foreign investors also. And especially if we look at the situation in corporate sector internationally, Pakistan Stock Exchange is the most lucrative and most profit earning stock exchange at the moment, especially in Asia, if I mention, because our market after pandemic, did not, earn the amounts of uh, profits, or the amounts of uh, outcome or dividend, actually, vis-a-vis Indian market or other Southeast East Asian markets. So at this point in time, this is really a very lucrative market, and the economy of a country is based on these companies. This is why this is always made sure that these companies must work within the purview of law, and no violation of law is allowed or encouraged, because people money is involved. If you go on PSX website, you will find that they have used the word Jama Punji. Jama Punji means your hard earned money. That means the money you have saved for your future. So people make investment in through stock exchange in different companies, and this is why Companies Act 2017, Corporate Governance Regulations for Listed Companies 2019, there are lots of requirements to be fulfilled, and you have just been through that. Chartered accountants are required to be employed. It is required that financial statements must be furnished well in time, and any violation of the same can entail penal consequences. Level 1, 2, or 3 penalties can be imposed. So this all mechanism is provided by the regulator, that is Securities and Exchange Commission of Pakistan, to ensure and to safeguard the legitimate lawful rights of the investors. So I'll pause here before we move on to the next activity. Thank you very much for your participation.